Hey guys, welcome back to the channel. Today's episode is a wild ride, so strap in. We're diving into the saga of a sovereign citizen who doesn't just take losses, he collects them like trophies. For him, losing isn't bad luck, it's practically a full-time commitment. Across 3 separate cases and 6 different hearings, he somehow manages to turn every single courtroom appearance into a masterclass in self-sabotage. Each moment is worse than the last, like a never-ending series of what not to do in court. And trust me, if you think it can't get more chaotic, it absolutely does. Let's jump in.
We are on the record with file number 22-186783, JP Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of JP Morgan Chase, P number is 82443.
And your name, sir?
Name for the record is I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand.
It's all right, Mr. McCardle, the issue isn't with you. When a document is complete nonsense, it practically exposes itself line by line. No one could reasonably interpret something the defendant clearly doesn't even understand himself. In truth, the person who sold him that fantasy paperwork likely had no grasp of it either. What you're seeing isn't legal reasoning, it's confusion passed along like an inherited tradition, each version just another layer of recycled, meaningless jargon.
So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay, so then I'll just calendar it, that's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainant.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
So you're asking for discovery, ambitious, but here's the reality. That kind of request actually requires a proper motion, filed correctly, served correctly, and written in clear, standard legal language. In other words, it has to follow real procedural rules, not improvised jargon or misunderstood templates. If you want this request to go anywhere, you'll need to submit something that genuinely resembles a formal motion, because without that, it never even gets off the ground.
Okay. Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you want, you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, JP Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of JP Morgan Chase.
Bar number?
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022.
This circus has been running since May 2022, and somehow it still hasn't packed up. If sovereign citizens have one elite level skill, it's their uncanny ability to turn even the simplest case into a drawn out marathon. They stall, delay, dodge, and stretch every step of the process like it's a craft they've perfected. But here's the part they never seem to grasp. No matter how long they drag it out, the outcome doesn't change. The clock runs, the patience wears thin, and in the end, it always lands the same way. They lose every single time.
A series of responses, as it were filed, the last of which is a response to plaintiff's counter-defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then in paragraph 8 our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically what I'm asking for is judgment in the amount of $18,610.79, in essence, because the defendant has agreed that he owes the money.
I'm definitely spotting a pattern here. The last sovereign citizen pulled the exact same move, spent the entire hearing loudly insisting the debt never existed, only to accidentally confirm every detail of it on the record. That's the inevitable result when your entire legal strategy is stitched together from oversimplified, unreliable sources. You don't just undermine your own argument, you end up strengthening the opposition's case piece by piece without even realizing it.
Mr. Campbell, your response.
I disagree, and I'll stand on my brief.
And you stand on your pleadings. Okay.
Which was
all right. The court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court.
Well, you certainly captured the special part, I'll give you that. Just not in the way you probably intended. Still, I suppose it counts for something. After all, a result is a result, even when it lands a bit off target.
We are on the record. We're calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Marcus Jamel Campbell special appearance.
First thing I want to know is Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirshenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr. Campbell, my question
Yes,
to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
I'd wager his so-called brief memorandum of law wasn't exactly a model of professionalism. And yes, a memorandum can be used to respond to a motion for summary disposition, but only if it actually meets the court's requirements, clearly explains why summary disposition is inappropriate, and supports those arguments with legitimate statutes and case law rather than unreliable late-night internet finds. If he somehow manages to do all of that correctly, it would be genuinely surprising, because nothing so far suggests that level of precision or understanding.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge-off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with a genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the court had the opportunity to read your brief, and I thought it was an interesting set of matters that you set forth here.
Forthwith is the judge's polished professional way of saying, "Sir, you clearly have no idea what you're talking about." It's the courtroom equivalent of a blunt reality check just wrapped in formal legal language. And honestly, I'll take it, because at least it keeps things moving without dragging everyone through more unnecessary nonsense.
But I'm prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's filed here, and I see
Yes, sir. That's all I need to know.
I know, for example, that you cite federal rules of civil procedure. I know, for example, that you cite 28 USC 2403. I further note you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor. There is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
He's already 0 for 2, and at this point, you almost want to believe in a third time's the charm moment, just not for his sake, but for everyone watching this slow motion legal train wreck unfold. Each case feels like another carriage coming loose, another preventable misstep turning into a full-blown derailment. And yet somehow it keeps going. Anyway, let's move on.
All right, this is case number 22196913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference. And I'm looking for Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. Right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right. Anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my fee schedule is on the record. That's all I need.
So let me get this straight. You're demanding they pay your fee schedule for trying to recover money you took and never repaid? That's not just flawed reasoning. It completely turns the situation on its head. If anything, it highlights a fundamental misunderstanding of how accountability works in a legal context. At this point, instead of making demands, the focus should probably be on addressing the original obligation, because doubling down on a position like that only makes things harder to defend.
All right. What I've received, and I've received your answer to the complaint in this matter, as I've indicated previously. That was filed with the court on March the 10th, and that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13, 23.
So on June 13th, he's handed one final opportunity to show even a hint of competence, a simple chance to demonstrate he can follow through on the most basic expectation. And what does he do? He completely wastes it by not even showing up. It perfectly sums up the pattern. Given a clear shot at getting something right, he still manages to fail at the easiest part, just being there.
Defendant in this matter, Marcus Campbell, or anyone representing Mr. Campbell, if you're on the Zoom, please say something at this time. The matter is set on for 9:30 a.m. It is now approximately 9:39. Let me ask you, counsel, have you had any contact with Mr. Campbell? Any response to the motion for summary disposition? Update me on any information that you may have at this time.
No, Your Honor, no response to the motion and no contact from defendant.
It's failed to appear. Moreover, in reading the motion and the issues raised thereby, as well as the predicate history of this these particular transactions herein, I don't see that there is a genuine issue of material fact in this matter, and that defendant, I have to conclude that the plaintiff is entitled to judgment as a matter of law. Moreover, I do not see where a defendant has raised a valid defense to the claim. And so the motion for summary disposition will be granted at this time.
Outstanding effort at this point. He's not just losing, he's turning it into an art form, stacking up mistakes like it's a competitive sport.
Michigan versus Eric Morton, 22F55126. I have received a petition requesting a court-appointed lawyer. I will sign that. You may proceed when you're ready, Mr. Hawthorne.
Your Honor, Mr. Morton and I had a chance to review and discuss the complaint, so we'll waive its reading on the record and stay on mute.
Okay. Ms. Reiser, did you want to say something about bond?
Yes, Your Honor. Amy Reiser, appearing on behalf of the people. We're asking for a surety bond, a very high surety bond, and I'm happy to place those reasons on the record in addition to what we've put in our bond recommendation form, that the defendant was just paroled in January of 2022 for convictions, several counts of very similar conduct. And in this particular case, the allegations are, and the video was recovered from his residence, that he placed cameras in multiple locations at Briarwood Mall and Starbucks and other coffee restaurants around Ann Arbor, and hotels to film individuals unbeknownst to them in the restroom. So there are at this time 9 listed victims that we've identified, and obviously multiple more. And I think the most disturbing part about the case is not only was the defendant paroled for behavior like this, but after the Ann Arbor Police Department executed a search warrant at his residence, they found further information that he had placed cameras in bathrooms in August of 2022, a date after the search warrant was executed. So I do believe he's a danger to the community, and we would ask that he be held on a $500,000 surety bond.
Okay, the bond request is 100,000. So you're,
Or 100,000.
Okay. All right. Anything else?
No.
What begins as a routine case introduction quickly turns serious as the prosecutor lays out chilling allegations, hidden cameras placed in public restrooms across multiple locations. Within seconds, the tone shifts from ordinary to deeply disturbing, and when a massive bond request is thrown in, you can already feel this case is far from normal.
And there is some of the images are of children, correct?
Yes, some of the images are of children using the restroom. We
Okay.
haven't at this time been able to identify those children.
Okay,
There is one piece of child sexually abusive material. That was located. That's separate from the filming in the restrooms. Child sexually abusive material was located on the devices that were seized at his residence.
I see. So
So that's count one.
that's count one. And okay, I see. So
And then the remaining counts with named victims, those are in public restrooms, and we were actually able to identify them. They were either employees, most of them employees
mhm.
of the locations where they were recovered. And there were children also in the restroom videos, but we have not been able to identify the children yet because they were customers of the businesses.
Okay. But and I know we can't, I know we don't know for sure. I'm just trying to clear something up in my mind. The allegations about cameras in restrooms, that is not targeting a particular demographic or specific people. That is a much more generalized behavior. Or do we not have any idea?
So
In this part, the situation takes a darker turn as the judge presses for clarity, and the prosecution confirms something deeply unsettling: children were among those unknowingly recorded. The mention of explicit material raises the stakes significantly, shifting the case from concerning to alarming. What stands out here is the growing weight of evidence, making it clear that this isn't just a minor offense, but something far more serious.
that's hard to say because everyone uses a public restroom
Right,
in a hotel and
Yeah.
at Starbucks and other establishments. So I can't say that he was targeting children in the
Yes.
bathrooms, but the genitalia of children were definitely observed using the restroom. We just were
Okay.
not, for the surveilling of an unclothed person, able to identify those children. We were able to identify the adults.
Okay. All right. Thank you.
Mhm.
Go ahead, Mr. Hawthorne.
Yeah, Mr. Morton has no violent prior convictions or offenses. He's gainfully employed. He states that he completed the terms of his parole without any violation.
Here, the defense steps in and attempts to shift the narrative. They present the defendant as a responsible individual, employed, nonviolent, and a caregiver to his young child. It's a clear attempt to humanize him and argue for leniency. This moment creates a sharp contrast, forcing viewers to question whether circumstances and character can outweigh the severity of the accusations presented earlier.
He is the sole caretaker of a 6-year-old son while the son's mother is currently hospitalized. He's worried that the high surety bond request would jeopardize his employment, his housing stability, as well as his ability to support himself and his family during this time. We're requesting a $5,000 10% bond with home confinement that allows for an exception with his employment, as well as compliance with all of the other bond conditions, such as no use of public restrooms.
So I didn't take the testimony on any of this. So I'm just going based on the documents that I have in front of me. Magistrate Nelson is the person who heard the testimony. So I think that as I understand the prosecutor's request, the biggest concern here is that Mr. Morton did successfully complete the terms of his parole and was able to be discharged from parole. He's now charged with the exact same crimes that he was on parole for, which, according to the information in the complaint, the criminal behavior occurred almost immediately after he was discharged from parole. And that is concerning because it indicates obviously he had some ability to do what he was ordered to do while he was on parole. And then as soon as he wasn't being supervised, was unable to do that, is the way this appears.
And I'm certainly happy to clarify that, Your Honor. I have knowledge of his convictions from 2015. Those stemmed from a porta potty at a Little League field in Ypsilanti.
I remember those.
Those were like children. It was further discovered that he had been some type of home health care worker and filming the clients without their permission when they were undressed. So
your point is that it is almost identical behavior. The surreptitiously putting a.
This is where everything changes. The court begins connecting the dots, revealing that this behavior isn't new. It's a repeated pattern stretching back years. The prosecution details nearly identical past incidents, making it clear that this isn't a one-time lapse in judgment. The realization that the actions resumed almost immediately after parole creates a powerful turning point, shifting the case from questionable to deeply concerning.
Camera in a bathroom of some type and filming that and then keeping the film.
Yes, and I would indicate to the court that based on the investigation, obviously the likelihood of conviction is very high because the complaints came from the stores at Briarwood Mall, from Bath and Body Works, from Altered State, another store at the Briarwood Mall. He himself, the conduct at the Bath and Body Works in Briarwood Mall was reported 5 days after he was paroled. But he had taken the camera with him and acted as if it was like a charging device. The employees at that store, the video in that bathroom was recovered at his residence during the search warrant. And so when he left employment, or I don't want to say was terminated, was let go, I don't know the circumstances, at Bath and Body, he then went and did the same thing at Altered State while simultaneously working at these hotels in Ann Arbor. So I don't know where he's employed right now, but he is definitely a danger to the community. The behavior just can't stop and hasn't stopped.
Yeah.
And I would also indicate that our investigation has shown when they executed the search warrant at his residence, he was living with his mother, who was also the caretaker of his son. So I don't know if counsel is aware of that, but I believe that his mother is able to take care of the son that was just referenced.
Mm-hmm. Okay, thank you. Did you want to reply to that, Mr. Hawthorne?
No, Your Honor, I have no
All
further
right.
response.
So, Mr. Morton, bond essentially has two questions that need to be answered. If the default is that a person should have a personal bond and not be required to pay money to leave jail. Unless the person is either a flight risk or a danger to the community. And unfortunately, the limitations of language, we're using the word danger, but that doesn't necessarily mean we're talking about whether someone is.
Now comes the decisive moment. The judge explains that danger doesn't always mean violence. It can mean repeated harmful behavior that impacts victims for life. With that reasoning, the court delivers its ruling, a high bond, rejecting leniency. The defendant's reaction says it all caught off guard by the severity. This final moment seals the tone of the case. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.